world over to any government to arena where they would like to claim their monopoly. First one is about finance or the token of money, which would ensure the commerce, and the second one is about the violence to maintain law and order. Today we are discussing about a particular law where these two monopolies are included, and in India it's been very stringent to ensure the preventive measures are in place, and even the bail under that law has been made very stringent. We are discussing about Prevention of Money Laundering Act and the bail conditions which would change hereafter after today's scenario. So to understand what changed, we need to understand the context that an MLC in Telangana, Kavita, has been granted bail in Delhi liquor policy case, which was actually conviction under PMLA, where the law was very stringent to grant the bail. So first thing first, what does money laundering is all about? Money laundering is about making sure some tweak or some loophole has been found to ensure there is a round tripping or evasion of taxes, to make sure the dirty money or the black money which you synonymously use are converted into the legitimate and white money. So one such case and one such conviction was in Delhi liquor policy case. Even Manish Sisodia, Kavita, all of them getting bails now. Now, those cases were observed in High Court differently. They were just following the procedure according to the law that was framed and the act of PMLA. Okay. Now, what changed today when it was challenged in Supreme Court, and what Supreme Court has changed and differed from the stance of High Court is what we are seeing today, and what can be implications of the future. So the first thing was about section 45 subclause 1 of PMLA has made the law draconian is what was observed. It was infringement of fundamental rights under Article 21 and 22, where though the preventive detention was existing, it has to be according to the law. And the famous notion that bail is rule and jail is exception has been upheld again, because the section 45 says the person who's accused can't be granted bail unless these two conditions are satisfied. The first conviction is the prosecutor was given enough chance to say why the tampering of evidence could be possible, and despite the tampering of evidence, why shouldn't the accused be granted the bail? The second one is to prove the court that the accused is innocent, at least to ensure the prima facie observation to court sounding to be innocent. Okay, sounds good, but this is in violation of Article 21 is what court was mentioning, because Article 21 says the onus to prove whether the accused is, he or she is innocent or guilty, is on the prosecutor and not on the defense lawyer. So that's what has been the stance in other cases, and why PMLA could be exception is the question. So if these questions has brought a new opening and new path has been paved using two doctrines, which is very much useful for your polity examinations. One being doctrine of eclipse, okay. The second one is about doctrine of severability. Just try to understand what these two are. Doctrine of eclipse says that if any law of the land is in violation of fundamental rights, then the fundamental rights would eclipse the law, and this is in compliance with Article 13 of Indian Constitution. So now, after this judgment, we could consider that PMLA section 45 has been eclipsed by fundamental right of Article 13. Okay. So this is the case. Fundamental right of Article 21, sorry. So the Article 21 would eclipse, according to Article 13, the PMLA law. Okay. Now, Article 21 has been put above any law of the land because fundamental rights would prevail over any law. Now, what actually is doctrine of severability? So, will the whole PMLA law becomes dysfunctional? No, the only section 45, subclause 1, would be eclipsed. So, this is what severability is. Severability is all about eclipsing partially. That means even if you stuck down or eclipse, you're not stucking down the whole law, but a part of it. So this, hope you understood the whole observation. And now let's look at the changes, how it can impact the future scenario. So when PMLA has been used this way, then the other laws like NDPS Act, Narcotic Drugs and Psychotropic Substances Act, and even the equivalent section would be in Bharatiya Nyaya Samhita regarding the hate speech, which was part of section 153A. So all these things have similar provisions that the onus would be on the accused or the defense lawyer to prove that the accused is innocent. Now the onus would be brought back to prosecutor like any other law. So in India, probably quoting the PMLA law, there can be a path that could be paved to ensure Article 21 and 22 would prevail over any law and there can be no exception, and the one after the other the exceptions would be removed to make India a different country where the fundamental rights would be more towards the absoluteness rather than the laws prevailing with the stringency. Hope you understood the whole scenario and the necessity of discussing these topics and the various doctrines which we discussed today. Another day, I'll be back with another current affair to bring the relevant thing which is necessary for your examination. Till then, thank you.